50 million times a year. That is how often American drivers get pulled over. 50 million encounters between a citizen and an officer, and in the vast majority of them, the driver hands over far more than their license and registration. They hand over their rights, voluntarily, without even realizing it. I need you to stop and think about that for a second. You are sitting in your car. Red and blue lights are flashing behind you. Your heart rate goes up. Your hands go to the wheel. And in that moment, that exact moment, most people shut down. They answer every question. They let the officer stand there as long as he wants. They figure he is in charge, so they wait him out. Here is what they do not know. The moment that ticket or warning is back in your hand, the officer's legal authority over that stop is finished. Done. And there are exactly 2 words that force him to either let you go or legally justify why he is keeping you there. 2 words that the Supreme Court of the United States has already backed up in writing since 2015. If you are not subscribed to this channel yet, do it right now, because what I am about to walk you through is not in any law school curriculum. It is not in the Police Academy handbook, and it is absolutely not something the system wants you walking around knowing. I have spent years going through hundreds of hours of body camera footage, studying Supreme Court opinions, and analyzing exactly how these encounters play out second by second. Today, I am giving you the full picture, not just the 2 words, not just when to say them, but the 6 things that almost every other legal channel out there gets wrong or quietly leaves out, and why that silence could cost you everything the next time those lights appear in your mirror. Stay with me. This one is important. Let me give you the full picture first, because without it, the 2 words mean nothing. Every single year, law enforcement conducts roughly 50 million traffic stops across the United States. 50 million. That is more than the entire population of California being pulled over every year on repeat. And for decades, the conversation around those stops has been almost entirely one-sided. The officer asks the questions, the driver answers them, the officer decides when it is over, and most people, most intelligent, law-abiding people accept that dynamic completely. They were never taught any different. But here is what the data tells us. And I want you to pay close attention to these numbers, because they are not opinions, they are documented, published, peer-reviewed findings. The Stanford Open Policing Project analyzed nearly 100 million traffic stops across more than 20 states. 100 million. What they found was this. Black drivers were stopped at a rate approximately 20% higher than white drivers relative to their share of the population. And here is the detail that should make everyone uncomfortable: that disparity shrank after dark. After sunset, when it becomes harder to see the driver's race through a windshield, the gap narrowed measurably. The researchers called it the veil of darkness. Draw your own conclusions about what that implies. Now move to New York City. The New York Civil Liberties Union released its analysis in April of 2025, covering the full year of 2024. The NYPD made 855,750 traffic stops in that single year. That is a 25% increase from 2023. Vehicle searches jumped 83%. Arrests from traffic stops increased more than 50%. And nearly 90% of everyone arrested during a traffic stop was Black or Latino. Do you see what is happening here? This is not anecdote. This is not one bad officer on one bad night. This is a system operating at scale, and it is operating with a very specific distribution of consequences. Now, I want to be precise here, because this channel does not deal in reckless accusations. The data does not tell us every officer making these stops has malicious intent. What the data does tell us what researchers at the Fines and Fees Justice Center confirmed in their 2024 report is that non-safety stops, meaning stops for equipment violations, registration issues, minor infractions unrelated to dangerous driving, are more likely to involve the use of force than stops for genuinely dangerous behavior. The incentive structure built into traffic enforcement is producing outcomes that the numbers cannot explain away. So when I tell you that 2 words can legally force an officer to end a stop, I need you to understand the weight of that. This is not a party trick. This is not content for people who are bored and scrolling. For a significant portion of the people watching this right now, knowing exactly what to say and exactly when to say it is not optional information. It is protective information. The playing field is not level. It has not been level for a long time. What I can do, what this channel exists to do, is make sure you walk into that uneven playing field knowing every rule of the game. And the first rule starts with 2 words. All right, you have waited long enough. Here they are. Am I free to leave? 5 words on paper, 2 concepts in a courtroom. And when you say them at the right moment in the right way, they do something that nothing else in that encounter can do. They force a binary legal choice. The officer must pick one of exactly 2 paths. Path 1, he lets you go. Path 2, he tells you that you are being detained, and the moment he does that, he has just taken on the legal burden of justifying why. There is no third option. There is no just hang tight. There is no gray zone unless you let him keep you in one. Now let me show you exactly where this comes from, because the power of these words is not my opinion. It is a Supreme Court ruling. April 21st, 2015. Rodriguez versus United States, 575 United States 348. Here's what happened. Dennis Rodriguez was driving on a Nebraska highway shoulder a minor traffic violation. Officer Struble pulled him over, ran his license, checked for warrants, inspected his registration, and issued a written warning. The legal mission of that stop was complete. Documents were back in Rodriguez's hands. By every constitutional standard, that encounter was over. But Officer Struble did not let him leave. He asked Rodriguez to stay so a drug detection dog could walk around the vehicle. Rodriguez refused. The officer made him wait anyway, 7 to 8 minutes. The dog alerted. Methamphetamine was found. Rodriguez was indicted on federal drug charges and sentenced to 5 years. He appealed, and the Supreme Court, in a 6-3 decision written by Justice Ginsburg, ruled that what Officer Struble did was unconstitutional. The court was explicit. A traffic stop can last no longer than the time needed to complete its mission. Once that mission is done, the authority of the stop is done. Extending it even by minutes, even by seconds, without independent reasonable suspicion violates the Fourth Amendment. The drug evidence was suppressed. That ruling is your foundation. That is the legal architecture behind the 2 words. But now I need to tell you something that almost every other channel explaining this case leaves out, because it is inconvenient for the clean, simple narrative they want to sell you. Rodriguez does not protect you automatically. It protects you only if the officer has not already developed what the law calls reasonable suspicion during the stop itself. And here is the part that should make you pay close attention for the next section. Courts have consistently held that nervousness, inconsistent answers, unusual behavior, and even the location of the stop can all contribute to building that suspicion in real time while you are sitting there, which means that by the time you ask the question, it may already be too late. That is exactly what I am going to break down next. This is the section most people think they already know. They have seen the other videos, they have heard about the 5 mistakes, they feel prepared, they are not. Because what those videos give you is the surface. What I'm going to give you right now is the architecture underneath it, including 2 mechanisms that almost no one talks about, that officers use every single day, and that can unravel everything you think you know about this encounter before you even open your mouth. Let us go through all 5, and I need you to stay with me through every single one, because mistake 4 and mistake 5 contain information that changes the entire picture. Mistake number 1, asking too early. The stop has a legal mission: checking your license, running your plates, verifying your registration, checking for outstanding warrants, issuing a citation or a warning. Until every one of those tasks is complete and your documents are back in your hands, the stop's lawful authority is still active. Rodriguez versus United States draws the line right there. Ask the question before that moment, and you accomplish nothing legally, but you do accomplish something on camera. You look anxious. You look eager to leave before the process is finished. And body camera reports routinely include language like, driver appeared nervous and was eager to leave prior to document review. On its own, that means little. Stacked with anything else the officer observes, it starts building a narrative. Wait for your documents. That is your activation moment, not a second before. Mistake number 2, asking only once and accepting the non-answer. The officer hands you your warning. You ask the question calmly, and he says, "Just hang tight a second." Most people nod and wait. That is a catastrophic mistake. Just hang tight is not yes. It is not no. It is a deliberate non-answer. And here is something those other videos will not tell you. That phrase and its variations, "Give me one moment," "Stay right there," "Just a second," appear across thousands of documented traffic stop transcripts. This is not improvisation. It is a trained technique designed to hold you in a legal gray zone while the extended time starts looking voluntary on camera. United States versus Mendenhall established the standard, whether a reasonable person would feel free to leave based on the totality of circumstances. An officer blocking your window while using vague delay language is creating circumstances a court can interpret as a seizure, but only if you document that you pushed back. Ask again. Stay calm. Ask a third time if necessary. Every calm, documented repetition is evidence your attorney can use. Mistake number 3, staying silent without invoking. In 2013, the Supreme Court decided Salinas versus Texas. The ruling, and I want to be precise here because this case is more complicated than most channels acknowledge, was a plurality opinion, not a majority holding. That matters legally. But here is the practical reality, regardless of the academic debate. Prosecutors in courtrooms across this country will use your pre-arrest silence against you if you never explicitly invoked your Fifth Amendment right. Silence alone is not enough. You have to say the words out loud. "I am invoking my Fifth Amendment right to remain silent." On camera, clearly. The moment you are told you are not free to leave, those words go out loud, not in your head. Out loud. Mistake number 4. Engaging with the redirect. After you ask whether you are free to leave, a trained officer will frequently respond not with an answer but with a new question. "Where were you headed tonight?" "You got somewhere to be." "Can I just ask you one more thing?" Berkmer versus McCarty, decided in 1984, established that voluntary roadside conversation is not custodial interrogation for Miranda purposes. Everything you say in that moment is fully admissible. What you may not realize is that those casual-sounding questions are not conversation. They are consistency checks. Officers are trained to cross-reference your answers against what they already know about your route, your location, the time of night. Any inconsistency, however small, however innocent, can be documented as reasonable suspicion to extend the stop independently of Rodriguez. Do not answer the new question. Redirect, re-invoke, return to the one legal question on the table. Mistake number 5. And this one carries 2 mechanisms most people have never heard of. The first is tone, and you already know the basics. Agitation gives the officer narrative material. Frustration, sarcasm, raised volume, all of it shifts the body camera report from driver exercised rights calmly to driver became agitated and erratic. That language opens a door, but here is the door behind that door, and this is what almost no one tells you. That language can trigger a welfare check framework. A welfare check does not require probable cause. It does not require reasonable suspicion of a crime. If an officer can articulate that he was concerned for your well-being based on your demeanor, that encounter can continue under an entirely different legal justification, one that Rodriguez does not touch. The stop is no longer about the traffic violation. It is now about you. And the second mechanism is plain view doctrine. Every second an officer remains at your window legally is a second during which anything visible inside your vehicle can become independent, probable cause for a search. A bag, a prescription bottle, a piece of equipment he finds unusual. Your tone is not just about optics. Your tone determines whether that officer finds a reason to keep standing at your window long enough to see something. Calm, polite, measured, and repeated. That is not a suggestion. That is the only combination that closes both of those back doors simultaneously and gives your attorney the cleanest possible footage to work with if this stop goes further. This is the part other channels skip. and I want you to think carefully about why they skip it. Some of it is because they do not know. Some of it is because the information complicates the clean, empowering narrative they are trying to sell. And some of it, in at least one category I am about to cover, is because acknowledging it would directly undermine a product they are recommending you buy. Let us start there. Dash cams. Every legal channel that covers traffic stops eventually tells you to get a dash cam. Record everything. Protect yourself. And that advice is not wrong, but it is dangerously incomplete. Here is what they leave out. The United States is not a uniform legal jurisdiction. It is 50 separate ones. And a significant number of those jurisdictions operate under what is called two-party consent law for audio recording. California, Florida, Illinois, Michigan, Pennsylvania, Washington. In these states, recording a conversation without the consent of all parties involved can constitute a violation of wiretapping or eavesdropping statutes. Courts in several of these states have wrestled with whether a dashcam recording of a traffic stop capturing the officer's voice without explicit consent falls within those provisions. The outcomes are not uniform. The risk is not theoretical. Before you mount that camera and hit record, you need to know the specific recording consent law in your state, because the footage you think is protecting you could, under the wrong circumstances, become a liability that your own attorney has to navigate around. Now, state law versus federal law, and this is a gap in almost every video covering this topic. Rodriguez versus United States is a federal constitutional floor. It is the minimum protection every American driver has. But several states have built significantly higher walls. California Assembly Bill 2773 took effect on January 1st of 2024. That law requires officers to state the reason for a traffic stop before questioning the driver about anything else. That is a protection Rodriguez does not give you at the federal level. New York, Massachusetts, and New Jersey have state constitutional interpretations and court precedents that provide stronger Fourth Amendment protections than the federal standard. Meanwhile, states classified as stop and identify jurisdictions, Texas, Nevada, Utah, and others, can legally require you to provide your name and identification upon detention. Refusing in those states is itself a criminal offense. The two words work differently depending on where you are standing when you say them. Knowing your state's specific framework is not supplementary information, it is foundational. Now I need to address something directly that most legal content creators on this platform will not touch. The data on racial disparity in traffic enforcement is not a political talking point. It is a documented, peer-reviewed, statistically rigorous body of evidence. The Stanford Open Policing Project's Veil of Darkness analysis found that Black drivers were stopped at measurably lower rates after sunset, when a driver's race is harder to determine through a windshield. The Fines and Fees Justice Center's 2024 report confirmed that Black drivers face higher rates of non-safety stops and discretionary searches. The New York Civil Liberties Union's 2025 analysis found that 87% of drivers subjected to use of force during traffic stops in New York City were Black or Latino. If you belong to a demographic that the data shows faces statistically elevated risk during these encounters, the information in this video is not academic for you. It is operational, and you deserve to hear it stated plainly instead of talked around. Finally, what happens after you are detained? Every channel stops at "I want an attorney," but that sentence is a beginning, not an ending. Here is what follows. Miranda rights are not automatic upon detention. They are triggered by custody combined with interrogation. You can be detained on a Terry stop legally held for a reasonable period without Miranda attaching, as long as the officer is not questioning you in a custodial manner. The moment formal arrest occurs, the landscape shifts entirely. If your vehicle is impounded, officers can conduct what is called an inventory search, a full search of the vehicle's contents without a warrant and without probable cause. Evidence found during an inventory search is generally admissible. This is a mechanism that exists entirely outside the Rodriguez framework and entirely outside the protections the two words give you. Here is the principle I want you to carry out of this section. Everything you do at the side of that road is evidence collection for a proceeding that may happen later in a courtroom. The roadside is not where you win. It is where you build the record that determines whether winning later is even possible. I want to pause here, because if I do not give you this side of the picture, I am doing the same thing I just criticized other channels for doing, giving you a one-sided narrative dressed up as analysis. So let me be honest about something. Not every officer who extends a traffic stop is acting in bad faith. Not every delay is a calculated power move. And not every moment of prolonged questioning is a trained interrogation technique deployed with malicious intent. Some of it is genuine professional instinct. Some of it is habit built over years of encounters where a few extra questions actually did surface something dangerous. And some of it is the product of inadequate training on the precise boundaries that Rodriguez established, boundaries that, frankly, many departments have been slow to incorporate into their standard protocols, even a full decade after that ruling. Traffic stops are genuinely dangerous for officers. Statistically, roadside encounters represent one of the highest risk situations in law enforcement. An officer standing at your window does not know you. He does not know your history, your state of mind, or what is in the vehicle. The caution that sometimes reads as overreach is frequently rooted in a real calculation about personal safety. That context does not excuse constitutional violations, but it does explain why the instinct to linger, to ask one more question, to keep the encounter going a little longer, is deeply embedded in the professional culture of traffic enforcement. Here is where my analysis lands, and I want to be precise about this distinction. The problem is not primarily individual officers making individual bad decisions. The problem is a system that has built financial and performance incentives directly into traffic enforcement. The Fines and Fees Justice Center documented in 2024 that traffic stops are used as criteria in performance metrics and grant evaluations across departments nationwide. When stopping more vehicles produces measurable institutional rewards, the volume of stops increases regardless of safety justification. That is not a character flaw. That is a structural incentive producing a predictable outcome. You can respect the individual while being clear-eyed about the system they are operating inside. Both things are true simultaneously, and both things are exactly why you need to know your rights with precision. Let me bring everything together. Today you learned that 50 million traffic stops happen every year in this country, and the vast majority of drivers walking into those encounters are unprepared for what they are legally entitled to do. You learned that 2 words, "Am I free to leave?" are not a courtesy. They are a constitutional trigger backed by a Supreme Court ruling from 2015 that the government spent years trying to limit. You learned that Rodriguez protects you only if you have not already handed the officer the reasonable suspicion he needs to extend the stop on his own terms. You learned that staying silent is not enough, that asking once is not enough, that a calm tone is not just about optics, but about closing 2 specific legal backdoors that most people do not even know exist. You learned that dash cams are a double-edged instrument depending on what state you are in. You learned that your state law may give you protections that the federal floor does not. And you learned that the data on who bears the heaviest weight of the system is not a matter of opinion. It is documented, it is peer-reviewed, and it is something this conversation has ignored for far too long. Now, I want to leave you with one question, and I genuinely want you to sit with this. If your constitutional rights depend entirely on knowing the precise legal language to invoke them in real time, under stress, without a lawyer present, are they really rights? Or are they a system that functions as designed for people with access to this information and as a trap for everyone else? Put your answer in the comments. I read every single one. If this video reached you before your next traffic stop, hit like right now because the algorithm determines whether it reaches the next driver before theirs. Subscribe if you are not already on this channel, because I am currently tracking 2 cases moving through the federal court system right now that could significantly narrow the protections Rodriguez gives you. When those decisions drop, I will break them down within 24 hours. You do not want to be reading about it somewhere else after the fact. The next video covers a specific scenario where everything you learned today stops working and where officers are legally trained to take the encounter in a direction that none of these protections can touch. It is already recorded. It goes up next. Do not miss it.